Hi friend, welcome to the Company Law Adjudication and Appeal series. Today we are discussing Southeast Region Regional Director Appellant Order for the violation of Section 42 of the Companies Act in the matter of Turnaround System Private Limited, where Regional Director reducing the penalty one-tenth of the total penalty imposed by the adjudicating officer ROC Karnataka. Let's see the facts of the case. This appeal filed by the appellant against the adjudication order passed by the Karnataka ROC for default in compliance with the requirement of Section 42 of the Companies Act. ROC, in his order of adjudication, stated that while processing the STK Form 2 application filed by the company, it was observed by the office that the compounding application which was filed by the company was pending for delay in filing PAS 4 under Section 42 of the Companies Act. Hence, adjudication officer directed the company to get the matter adjudicated under the said section. Based on the said letter, this office issued adjudication notice to the company and director to attend a hearing to adjudicate the matter. Matter was heard during the hearing. ROC has directed the authorized representative to file a written submission in order to examine the matter further. It is noticed that from the adjudication application and written submission that the company has raised 14,85,000 through private placement by issue of fully and compulsorily convertible debenture and has circulated letter offer in 2014. From the MCA record, it is noticed that the said office was made to TG Holding Target, a general partnership having its registered office at Barmula, Foreign Territory, to amount of USD $25,000. The company was required to file letter of offer with the ROC in Form PAS 4. There is a delay in the filing of this form in 42 days. Further, the company in this letter submitted that the company has incurred a huge losses and stopped its commercial operations since 2016. The company and its director who had invested huge amount of money but incurred heavy losses. The company has also applied for closure under Section 248 of the Companies Act. Hence, the company has requested to take a lenient view on the default committed. Further, it is stated that MCA has done away with the requirement of filing of letter offer in Form PAS 4 with the ROC. However, it is silent as to whether the amount of 14.85 lakh raised through the FCD has been refunded to subscriber or not. Whereas it is seen from the financial statement of the company as at 31st March 2021 that the paid up capital of company is 1,05,057 and turnover is nil. Further, the company does not hold a status of subsidiary or holding. The company therefore comes under definition of a small company, hence the provision of levying lesser penalty as provided in the 446B of the Act is applicable to this company. And this adjudication order, ROC has imposed a penalty on the company and two officer in default, the two director, and the total penalty imposed here is the 22,27,500. That is the 7,42,500 on company and 7,42,500 on two office director who is the default. That is the considering company is the small company and 50% of the amount raised by the private placement imposed as a penalty on the company and the two officers in default. And total penalty imposed here is the 22,27,500. An opportunity of being heard was given to the appellant. The authorized representative appear on behalf of the appellant and submitted submission made in this appeal that the company has furnished following grounds in his appeal. Here is the grounds. The members of the company in their EGM held on 3rd July 2014 have approved to issue 0% fully and compulsorily convertible debenture of rupees 100 each, equivalent to 25,000 USD. On the date of the receipt of the fund, we offered to the TG Holding Target a general partnership having registered office at Barmulla, foreign territory. Subsequently, the company has circulated the private placement to the proposed investor. Uh, Pursuant to the provision of Section 42, Subsection 7 of the company, as offer covered uh, under this section, shall be made only to such person whose names are recorded by the company prior to the invitation to the subscriber, and that such person shall receive the offer by name, and that a complete record of such offer shall be kept by the company in such manner as may be prescribed. Pursuant to the aforesaid provision, company was supposed to file the letter of offer with the ROC in form PAS 4 as an attachment to the form GNL 2 on or before 2nd August 2014. However, there is a delay of 42 days. Further, target company has accepted the offer of the compulsory to subscribe 0% FCCD and accordingly remitted 25,000 USD to the company. The board of directors of the company in their meeting held on 28 August 2014 has allotted FCCD to the target company, and subsequently the company has filed return of allotment in form PAS 4 with the ROC and has specified the time period as mentioned in Rule 6. The form GNL 2 was sent for a resubmission by the ROC with the remarks that it is seen from the PAS4 that the letter offer was issued on 3rd July and the same has to be filed within 30 days from the date of offer, where the same has been filed only on 13th September 2014 after a delay of 2 months and 11 days. You are requested to compound the offence or otherwise the e-form be rejected under further requested and further PAS 5 note file. In response to the resubmission remark made by the ROC Karnataka, the company has filed an application for the compounding of the offences under Section 42, Subsection 7 of the Companies Act. Further, the members of the company in its EGM held on 30th March 2019 has converted existing 14,88,050 FCCD each held by the target company at a predetermined valuation into 557 equity share of rupee 1 each at a premium of 2,692 per share as per the terms of the condition mutually agreed between the company and debenture holder at the time of issue of debenture. The company has utilized the entire amount received in the form of FCD from the target company for the business purposes, and after all the required filing with the ROC, the company has given employment of 7 employees. However, the company has incurred huge loss and stopped its commercial operation. Also, the company has made an application for a strike of the name of the company by form STK2 on 18th November 2021. And in response to the aforesaid application filed under Section 248 of the Companies Act, ROC had sent adjudication hearing notice to the company and officer to adjudicate the penalty under Section 454 of the Companies Act for non-compliances of Section 42 subsection 7. And company in its appeal has stated that the company has incurred huge loss and stopped all the commercial operations since 2016 and already made an application for a strike of the name of the company under Section 248. Though there is a default committed, there is a ground interfering with the impugned adjudication order of the ROC to the extent of reducing the quantum penalty due to the following grounds. Company has incurred huge loss and stopped its commercial operation. Since 2016, company has made an application for a strike of the name of the company under Section 248 and taking into consideration of the appeal filed by the company, and since the company has already made an application for the strike of the name of the company, the penalty here imposed is reduced to uh, 1/10 of the total penalty, 10% reduced to 10%. That is the uh, 7 lakh 42,500 to 74,250 on the company, and same on the official default. The total aggregate penalty imposed here is the 2,22,750 by reducing the 10% of the total penalty imposed by education official. Thank you so much for watching this update. In case of any query, you may raise your query in the comments box. Thank you so much.